Thanks for joining this week's edition of the Tuesday Toolbox. I'm here with Wendy Zambroni, who's one of our members, and Wendy is an IP attorney. Tell us a little bit about your firm.
Thanks, Nancy. My firm is called Talem Intellectual Property Law. We are located in Gainesville, Florida, and we are a woman-owned IP law firm that was founded in January of 2015.
So your firm practices intellectual property law, otherwise known as IP. What exactly is IP?
IP has four main categories. The first is patents, which is what you think of when you think of an invention. And the second is trademarks, which is your brand name or service mark in commerce. The third is copyrights, which is an original work of authorship. And that can be a book or a play or a movie or a sculpture or a piece of software. And the last type of IP is called trade secrets. And trade secrets is something that is kept confidential by a company for their competitive advantage. And that could be a customer list or a secret sauce, something that they don't disclose to the public, and that helps them maintain their competitive product.
Great. What can someone do if they have an idea or product that they'd like to protect?
So there's really a few different things they could do. The first would be to file a utility patent. A utility patent relates to an inventive idea, and that is, kind of what you think of when you think of a patent. That's what you're envisioning. It's a utility patent, and it has to be on something that's new, useful, and non-obvious. And it can be any number of things, but it could be a composition of matter. It could be a pharmaceutical compound. It could be a machine or a device. So that's what a utility patent is. The second type of intellectual property protection for a product is a design patent. A design patent protects the ornamental design of the product, so the industrial design. And these design patents are being used a lot right now. And they're different than utility patents because they don't protect the usefulness or the utility of the device. So one example is in headphones. There's a lot of headphone companies right now, and headphone technology has been around for a long time. So they can't get utility patent on the useful aspect of the headphones, but they can protect the aesthetic design, and that can give them an advantage in the field. So a lot of headphone manufacturers have been filing design patents. And the last type of IP is that you could use to protect a product is copyright. Copyright can protect software, it can protect mobile apps, movies, and books, other things that are works of authorship. So copyright can be protected and either sold as copies, or it could be licensed. So you'd have a license to use a piece of software or mobile app.
Mm-hmm. Okay. And what about a brand or logo? How can a business safeguard their brand or their logo?
So you'd safeguard your brand or logo by filing a trademark. And a trademark is your service mark in commerce. It's your mark for your goods in commerce. It's the way that people recognize your brand or your company and know that the products originated from you. So there's two different types of trademarks. There's state trademarks and there's federal trademarks. A state trademark is filed in your state, and there's, like, Florida calls it a fictitious name. Other states call it doing business as. And that protects your name doing business in the state. But if you're doing business across state lines, you want to file a federal trademark. And there's different types of trademarks. And one's called a word mark. It protects the actual name that you're using, the words. Another is called a stylized mark, which protects your logo. And filing for trademark protection is going to protect you from others using marks that are likely to confuse consumers, that the consumer would be confused as to who originated the goods and thinks the goods came from your company.
Mm-hmm. And once you file that trademark or copyright, do you have to keep filing that, or is it one and done?
So with a copyright, you only have to file it once. With a trademark, you actually have to renew the mark every 10 years, and you have to file a statement that you're still using it. So you file it, and then you file a statement that you're still using it. And at the 10-year mark, you renew the mark, and you actually can do that in perpetuity. So as long as the trademark system exists, if you meet the deadline every 10 years and you're still using your mark, you can continue to have trademark protection.
How can utilizing IP protection actually add value to my business?
So intellectual property is a tangible asset, just like a piece of property or a building that your business could buy. So when you invest in developing IP, it can create value in protecting your product and also protecting your service line, and give you opportunities to protect your interest in the market that you're in. So if you had a competitive advantage in one field, you can protect that and prevent your competitors from exercising there in that area. So it's actually what's called an exclusionary right. It helps you exclude others. And by building that, you can build value. And as the market increases or demand for your product increases, that continues to grow. And as I said, that's a tangible asset. So that asset can then be transferred and bought and sold and licensed against, and you can even take out loans against it in some circumstances.
So you should then really view it as a business strategy.
Yes, correct.
Great. What can I do if another business has an idea or brand that I want to leverage to grow my own company?
So there's different opportunities to transfer intellectual property through licensing. You can buy and sell intellectual property. They're called assignment agreements, or you can license other people's intellectual property or license them your intellectual property. So oftentimes, if you find a business and they have IP that you want, you can take a license and bring those rights into your business. So you can incorporate them into your own product, or you could also take aspects of your product and license them to companies or competitors and use that to generate revenue. So you want all of this to be part of your strategy on how to create value for your business.
Wonderful. And then finally, what questions should you ask an IP attorney before you engage them?
So you really want to make sure an attorney is going to look at your whole business model and understand how you make profit, how you make revenue, and how to grow that and increase that. You want an attorney who's going to be your strategic partner as opposed to someone who just generates expenses. So you want to ask them, if you're looking at a patent, how are they going to investigate competitors? Are they going to do prior art searches and search other patents and publications? And they're going to ask them how they're going to work with you from a business development angle to grow your IP portfolio in a way that creates value. Equally, if you're working with someone on the trademark angle, you want to make sure they're doing proper trademark searches in this country or internationally, depending on your business, so they protect the IP in a way that you can grow your brand and create value and minimize potential risks.
Great. Well, thank you very much, everyone, for joining us. It's been a pleasure to be with you, Wendy.
Thank you.
And if you have any further questions regarding intellectual property law or patent searches, etc., visit Wendy's website. You want to tell us your website?
Yeah, it's talemip.com, talemip.com.
And if you need more information like this, please subscribe to our Tuesday Toolbox YouTube channel. Thanks. See you next time.